Alex here with a video on legal nuts and bolts. This video is going to cover execution. So, some people did ask about this because I guess, I don't know, they were amused by the idea that I could like garnish my ex's wages and like levy bank accounts and stuff without using the district attorney. Like, a lot of people know that you can garnish child support, but not many people know that you can do it yourself without the district attorney. And the only reason I knew this is because I worked in collections for quite a while, and I figured out how the process works. So I decided, after all this time, I guess, there's a gap in my my topics list here that I can cover execution, because I know some people are curious as to how it works. I will talk about how I've done it personally in the past, and I will go over the different methods of execution in Nevada. Now, that word might be misleading. Some people might think execution like death penalty. It's not what I'm talking about. Execution is basically executing on your case when you've won. So when you file like a lawsuit, a regular lawsuit, whether it's a towing complaint, something against your landlord, whether it's a justice court civil action or a district court civil action, whether it's in your child custody case, because in your child custody case, at least in Nevada, you can get some judgments on certain things. You can get a judgment on child support arrearages, and you can get a judgment on medical reimbursement. So like, say your ex was supposed to pay you like half of a surgery and they didn't do that. You can get a judgment. So those are the examples of how you get a judgment in a child custody case. In a normal lawsuit, you get a judgment after trial. So like in a small claims, it's like a one-day thing. Small claims is filed, you go to court, you argue, kind of like Judge Judy, and if you win, you get a judgment. In a civil action, that's whether it's in the justice court or the district court, it's a little bit more involved. Motions will get filed, pleadings papers, there'll be discovery. It's like I said, it's a formal action, and then at the very end there'll be a trial. Or sometimes you'll win by dismissal or by a summary judgment. That happens sometimes, and you'll have your judgment. The judgment is the key to everything when it comes to execution. Without the judgment, you can't do anything, and it's only fair because you haven't won yet. Once you have your judgment, you've won, and inside of a judgment, it will say how much money you're entitled to. Now, that's just a piece of paper. Execution is how you actually get that money. Some people will just pay you, like really, some people will just say, I've lost, here's $1,000, that's what I lost. Other people won't pay you. They just, whether they if they can't afford it, usually they'll be protected by the exemption statutes, which I'll go into in a second. But a lot of times it's because they don't want to despite you, especially in a child custody case. Child custody case, you're not going to get paid because your ex wants to spite you. They hate you. Or it's because they have issues. So like when I worked in collections, you can't really execute on poor people. There's all these exemptions, and they protect poor people. You can't take their stuff because they don't have enough to take. They have a right to live. And so you'll just end up with a judgment that says you won, but you can't actually get the money. But a lot of people, like I mentioned, they have issues. Like, they're not paying because they're gambling all their money away, or they got like all these expensive things like cars and like all these expensive like a expensive cell phone, expensive car, and their insurance and payments are too high, and so they're just not responsible. Sometimes people are addicts, like they're an alcoholic, they're always at the bar and they just waste all their money, and so most of collections is going after those people because they have the means, they have the money, they're not poor. They just won't pay you because they have issues. And so you use execution to intercept their money before it gets into their hand. That's the name of the game. Execution is you intercept that money before it gets into the hands of the person who is going to squander it, or is being spiteful. So here's the different tools. The most popular is the garnishment, which is basically taking money out of people's paycheck. It's the most common. The second most common is the bank levy. The bank levy basically gets sent to a bank, and they take the money out of the bank account. I've used both of those. The third most common is the till tap. You can't really do this one on people. The till tap is done on businesses, and I've done that twice. What happens with a till tap is the sheriff goes to the place of business and opens up the cash registers and takes the money out. I did that to a Jack in the Box, and I did that to a Verizon Wireless. Both of them were in Reno, And I got $1,000 out of both of them. This was when I was working collections. This was not like, this didn't involve my ex. And the sheriff just went down to the Jack in the Box and opened the registers and took the money out. And for the Verizon Wireless, it was tricky. There was like a bunch of registers, and they opened all of the cash registers and emptied all of them out. And then there still was money in like a bill pay kiosk. I guess there's like a Verizon Wireless, like a bill pay kiosk where people go to pay their bill. They cracked that sucker open. They took the money out of there too. So the till taps are some of the most exciting. I don't know why businesses won't pay their judgments. I mean, I guess they just don't know that you can send the cops down there to take their money. The next most popular one, I guess, would be the putting a lien on a house and foreclosing. I've never done that one. And then after that, there's another two. You can tow someone's car away and sell it. And then you can, the one after that is, the least common is the writ of possession. It's like where you take somebody's stuff away and you like sell it at an auction. Like I heard that like you can do that with like couches or like jewelry or furs, but it's really rare because it ends up costing money to like auction it and transport it and tow it and all that, and like you don't usually get the full value for it when it goes to auction. You get like a fraction, so it's just the least common, the writ of possession, writ of possession. Some states will allow you to do one extra one. Now this one's really cool. I don't think Nevada allows it though. Basically, you pay the sheriff to send a deputy who just goes and stands at the place of business. And he just stands there. And anytime somebody comes in to buy something, he takes the money. So it's pretty cool. I think it's like a California thing. It might work in other states too, but I've never done that one before. The tail tap, actually, the sheriff shows up, takes the money out, and if there's none in there, they leave. They don't stick around and wait for customers to come in and buy stuff. They just leave. So how does it work? I don't want to go into too much detail because you really got to learn this for yourself, and it could change. Basically, you have to file. Well, you don't file it. You have to ask the clerk of the court for a writ of execution, and you fill it out. I actually like to type up my own because it looks more professional. But you can, in Nevada, you can just go to the clerk's office and ask for a writ of execution, and they'll give you one with like all these fill in the blanks, and you can like put the dollar amounts and fill it out. It basically asks you to refer to the judgment that the judge entered. So you put on the writ of execution. Here's the case number. Here's when I won. Here's the judgment. Here's how much money I get in principal, in interest, in costs, in attorney's fees. Here's how much interest I get, because there's like a legal rate of interest. You can get money for how long it's taking your opponent to pay it. You fill that thing out, and then the clerk will put a seal on it. It's like a raised seal, similar to a subpoena. They'll put a seal on it, and that once they put that seal on there, it's considered issued. You also have to pay a fee. It's like $10 in Nevada to get the writ of execution issued. So if you do like 4 of these, then you have to pay $10 for each. And you can actually tax the costs as accrued costs, which are different from regular costs. Normally, you have to ask the court for an award of costs, and you have to show how, under the law, you're entitled to it. For accrued costs, the clerk just believes you. It's like it's not even supervised like by the judge. If you paid $40 for those writs of execution, you just write in there $40, and nobody supervises, nobody checks that. That's just trusted. I highly recommend you don't lie on there because that could really come back to bite you. I imagine there's some kind of penalty statute somewhere in there for abusing the execution process. In Nevada, the execution process is really hands-off. The judge is no longer involved. So you, as the judgment creditor, have a lot of leeway to take stuff away from your opponent. And unless your opponent files things, you're just going to steamroll them. Because it's like I said, nobody's watching you. You're no longer going back to court and asking for things. You're just taking things. You just taking. So with my ex, I got a judgment against her. She refused to pay, and I filed a garnishment of her wages, and I filed a bank levy. Like I said, I didn't use the district attorney. I didn't use child support enforcement. I just did it myself. And I went down to the courthouse with my writ of execution, and I filled it out. And then I got both of those writs of execution issued. I paid the $20, And then I went to the sheriff. Okay, so that's the second phase. I haven't told you all of the instructions yet. The writ of execution is the clerk acknowledging that you have been awarded monies. It's only one part of the process. The sheriff does the rest. The sheriff needs the writ of execution, obviously, because the sheriff needs to know that there's a court that says you are owed money, or the sheriff won't do anything. Without that writ of execution, the sheriff does not have the authority to seize things. The second thing the sheriff needs is instructions. The sheriff is not going to just on his own send deputies out to get money for you. The sheriff will follow your instructions. So if you want to garnish your ex's wages, you have to get a writ of garnishment. Now that is not, the clerk of the court does not fill that out. They don't stamp that or anything. That's just something that you can build yourself, or you can download off the internet. They're in it's in the statutes what it's supposed to look like, the writ of garnishment. And then the writ of garnishment, you'll have to fill it out. And I think it just takes a little bit of information, like the case number, your ex's name or your opponent's name, where they work, the address of where they work, where you want the sheriff to serve the writ of garnishment. And then it'll also have on the back of it, it'll have like they call them the interrogatories. There's a name for them. I think like employers interrogatories, or interrogatories to the garnishee defendant, something like that. Basically, what happens is the sheriff will take the writ of execution and the writ of garnishment, and they'll hold on to the writ of execution, and they'll deliver that writ of garnishment to the address that you told them to deliver it to. So typically that's going to be an employer, and they'll take it to the employer. Or a bank, like I said, you can use it, you can like levy a bank account, or there's all those other examples. You can tap a till. It's just important that in the writ of garnishment you have an explanation telling the sheriff, go here and tap the till, go here and garnish wages, go here and empty out our bank accounts. And the sheriff will go and they will serve that. Now, oh, by the way, let me stop you right here. I've mentioned in previous videos how service of process works. And I've mentioned how certain things have to be served personally. Certain things can be served by mail if you want to optionally. Certain things can be served by you, certain things can't. Sometimes you have to have somebody else serve something. The writs of execution, the writs of garnishment that take away money or seize assets, towing away cars, leaning on a house, tapping a till, garnishing wages, levying bank accounts, this process must be served by the sheriff. You cannot use a company. You cannot use a friend. You can't do it yourself. It must be served by the sheriff. It's that strict, because they want to supervise this process. They don't want people serving these scary garnishment levy things and defrauding people and taking away their money from their accounts. So the financial institutions, the employers, they know that if the sheriff didn't serve this, something's not right, because the sheriff is the only one who can serve these in Nevada, at least. Okay, so once an employer or a bank, so like if it's a bank, once an employer or a bank or whoever gets this writ of garnishment, once they have that, they are now compelled to follow the instructions on it. And on there, it'll tell them. So there's instructions to the sheriff, which says, drop this off at this employer. And then there's stuff on there for the employer, which will say, you are hereby commanded to withhold a certain percentage of this person's paycheck and turn that over to the sheriff's office. And then on the back of that, they'll have to, I mentioned the interrogatories, they also will have to answer those. They'll have to, interrogatories is a list of questions, basically. I'm going to do a separate video on what interrogatories are, because they're also used in discovery. It's a list of questions that the employer or the bank or whoever has to fill out. And it typically asks questions like, do you owe this person money? Do you pay this person a wage? How much do you pay them on average? It asks some questions like that. Once they fill that interrogatories out, they send that back to the sheriff, and then the sheriff will forward that back to you. So then you can read that and you can be like, okay, cool, they're earning this much money, so I'm probably going to get this much per week from them, or per month. I forgot how often the sheriff takes the money and forwards it to you. It might be monthly. And I can look at that and I can say, okay, that sounds fair, that sounds real, it sounds like it's honest. Or I can challenge that, and I actually did have to do that one time. I challenged it because the bank my ex was banking with Bank of America, and Bank of America refused to give me the money in her account because it was under $400. Now, normally they're supposed to do that, but because this was for child support, there's an exception. So I sent them something called a reply to garnishy defendants interrogatories. Maybe I'll post later on. I might give people some places where they can find samples of what these things are so that they can get them themselves. But anyway, what it does is it tells Bank of America, you've made a mistake, you applied the wrong statute, and if you don't comply, then I'm going to impose sanctions, and I'm going to go into that next. But anyway, I did serve that to Bank of America, and they got it, and they actually gave me her money. They just basically confused it, and they thought it was a normal judgment. They didn't know it was for the support of a child. So that $400 rule didn't apply, so they just emptied out her whole account. Where was I? I think that covers the interrogatories. How to challenge them. I wanted to cover a couple extra things. Also, there are varying different requirements for how some of these things work. So for example, when you're garnishing someone's wages, it only is good for 120 days. So they'll garnish their wages for 4 months and then they'll stop. You have to do another writ of garnishment. If you're doing a normal civil action, if you're doing child support, it just keeps going forever and ever. But if it's for like a normal lawsuit, it goes for 4 months and it stops. And then you have to go back and ask for another one if you want to keep taking their money. Obviously, that doesn't work for like a bank levy because it's just like a one-shot deal. They empty out the account, they give you the money, and they're done. They don't keep taking their money for 120 days. It's just that one thing, one time. Till tap, same thing. They tap the till, take all the money out of the cash register. That's it. It's over. So you look into those little quirks if you're trying to figure out how that works. I think this is going to be a lot more useful for people who win like a normal lawsuit. A lot of people who win like a child support award, they're not going to want to do all this crazy stuff. It's complicated, it takes work. They're just going to want to have the district attorney's child support enforcement agency do all the work. But I'm just letting you know that in Nevada, I was able to do it. And actually, after a while, even I got annoyed with it. And now the child support enforcement has taken over. It's just easier. But I mean, I tried it myself. I was hoping that by me seizing her assets, she would actually want to pay. But she just got worse, and she was just like, I'm not going to give you anything, which she wasn't doing anyway. But it was like, well, that didn't work. Okay, child support enforcement, you can take over because I don't want to waste time on it anymore. Of course, I can still change my mind and like, decide to go back into it. And I don't know, like if I figure out she has a bank account somewhere, I could try to levy that account or something. But at the moment, I'm just kind of letting that go on to autopilot. So I wanted to cover couple more things. One of them was I mentioned exemptions. So as I mentioned, you can't seize the assets of a poor person, but they're not automatically protected. So if you're like a college student, hopefully you're watching this video and you can pay attention to what I'm about to say. Two things are protected. One of them is your bank account, up to $400, as I mentioned. The other one is your wages. They can only take 25% of your income, or it's like 50 times the minimum wage, if I remember correctly, per week. So like, say the minimum wage is $10 an hour. Then they would do 10 times 50, that's 500. And so that means if you're making less than $500 a week, they can't take that money. Sometimes it can get in this really gray area. Sometimes you'll be making more than $500 a week, but it won't be enough that it's equal to 25% of your income. So like, say you're making like $550 per week. Well, in that case, they can't take 25% because that would drop you below $500. So they'll just take that 50. So they'll garnish $50 per week. If you're getting 600, that's different because that should be, well, $600. 25% of that's 90. That'll drop you to 510. Yeah, you'll be above the threshold. So they'll take 25% of your income. Anyway, the point I'm trying to make is it's either the difference between 50 times the minimum wage or it's 25%, whichever is lesser. So the lesser amount is how much you're getting garnished, and that does include zero. If you're making less than $500 a week, you can't be garnished. You get to keep all your paycheck. That's what I was talking about with you can't really go after people who are poor because they're protected, which is fair. People need to live. And creditors like loan companies and stuff, they look into that, and if somebody's not making a lot of money, then they just are more cautious about giving them money because they know that if they have to go after them, they'll have a hard time getting it back because you won't be able to seize the wages. As I mentioned with the bank account, $400, unless is protected, you can't take it all the way down to zero, except with that exception about child support being support of a person, so it's not protected, they can empty you out. There are other curious protections, things that I really have never looked into, like SSI, disability, military benefits, all that stuff you have to look into yourself. I know that stuff is covered in the exemption statutes. I just don't know the particulars, but my understanding is that federal benefits are typically pretty tough to get on a normal judgment. Of course, exceptions apply for child support and alimony. There's probably ways to get around those protections. That covers the exemptions that I wanted to talk about. Oh yeah, in Nevada, if you want to claim exemptions, you have to file, the judgment debtor, you have to file an affidavit claiming exemptions, because sometimes you'll have oddball things that you want to protect, like your car, your house. And if you don't go to the court and get that affidavit claiming exemptions, sometimes a nefarious judgment creditor or collection agency will try and take your car, or you take your house. And my understanding is that if you have your house homesteaded, that's one of the exemptions. And if you only have one car, they can't take your one car. You have to look at the actual statutes, because I think if the car is worth a certain amount of money or more, they can take it. And I know for sure if you have more than one car, they can take one of the cars. But if you just have one, that's in there. That's in the statutes. So make sure you file that affidavit claiming exemptions and tell the court, I want to protect my car, my house, and just list the things that are covered in the statutes. And then the judge will have set a hearing and he'll tell them, you cannot execute on, their one car. You can't execute on their homesteaded house. I had one curious wage. It was actually really smart of her. It was a teacher. I didn't know that this is how they were paid. I thought they were paid the whole year. But this teacher claimed that she got paid 9 months out of the year. Maybe she was a substitute or something. And the 3 months during the summer, she wasn't paid, and she wanted the court to average her income over the year. And the court agreed, and they averaged her income over the year, and she ended up being exempt or something like that. I just thought it was a smart way to handle the exemptions. She filed it, and it worked. So we couldn't take her wages. This is when I worked at the collection agency. The next thing I wanted to cover was, I forgot. There's two things. There's two more things. One of them is supplementary proceedings, and the other one is sanctions, when you need to sanction somebody for ignoring your writ of garnishment. So supplementary proceedings are used to figure out where assets are. So I've given you all the tools and the patterns that you have to follow, the procedure you have to follow to seize someone's assets. But what if you don't know where their assets are? You do have a right to ask, and it's called a supplementary proceeding in aid of execution. So basically, extra court stuff to help you take their stuff. There's a couple of ways you can do it. One of them is by filing formal discovery instruments. I've never done it that way before, but in the rules you can do that. You can send them interrogatories, requests for admissions, all the other discovery tools. But this time you'll be asking questions as to, like, where is their money at? Where are your bank accounts? How many cars do you have? The other way, which is a lot more common, is the debtor's exam. So you can just say motion for debtor's exam or a motion for supplementary proceeding in the aid of execution, and then inside of there you ask the court to set a debtor's exam. Lawyers usually will do these, when I worked in collections anyway. You won't do it in court. They'll do it in like their office, and they'll have a court reporter there with a little machine, and they'll just like ask you a bunch of questions as to what I mentioned before, like where's your cars, where do you work, how much do you make, stuff like that. They're going to try to find where your stuff is so that they can take it. And that's basically how that goes. They call it a debtor's exam. Sometimes, a lot of times, people won't show up to their debtor's exam. You can actually have them held in contempt of court and put in jail. A lot of people don't like this because they'll say, it's not fair that I went to jail for not having money. It's like a debtor's prison. Well, that's not true. You're not in jail for being poor. You're not in jail for owing money. You're in jail for ignoring the orders of the court. If you're too poor to pay on your judgment, show up to the debtor's exam and tell them, answer the questions. And you can't be, if you comply with the order of the court and you go to your debtor's exam and you answer all your questions honestly, you can't be put in jail. The reason people get thrown in jail is because they just don't go. They're ashamed, they're pissed off, they don't want to pay, or they just don't have money and figure what's the point. But, well, there is a point. You need to comply with the order of the court. That's how you get put in jail. On that order, we've done this in collections before. I don't work there anymore in collections anymore, but that's how it went. It's like you filed a motion for debtor's exam. I would do like 10 of them. One guy would show up out of 10. And then on the other 9, you ordered to show cause them for failing to comply with the order of the court. They don't show up to the show cause hearing. Half the time they don't show up, sometimes more. Then guess what happens? Bench warrant. And there's been people who've been picked up on a bench warrant because they owed money. And it's like all you had to do was just show up and answer the questions, and then you'd be left alone. But at least for a while. I mean, you won't be left alone forever, but it's like you might get questioned again like 6 months later just in case you got a new job or something. But please, just like all you have to do is just comply with the order of the court and you won't be put in jail. But a lot of people don't do that. Now, if you're the judgment creditor, hopefully that's what's the word? Hopefully that instills some confidence in you, because now you know that if you win your lawsuit, you have all these ways that you can get the money. And if you don't know where the money is, you can haul them back into court to answer your questions. And if they don't answer your questions, you can get them thrown in jail. So it's like you have a lot, as a judgment creditor, there's a lot you can do. It just takes work. The last thing I wanted to cover was sanctions. So this actually was a huge deal when I worked in collections. When I got there, my predecessors, the people who ran the department before me, did not know that you could do this. And so I was able to go back like 2 years. There was like a statute of limitations. It was like a year or two, I don't remember. I was able to go back like a year or two and go after all these employers and all these institutions that ignored the garnishment order. And in Nevada, it's actually in the statutes. I don't remember what you could probably find it under the chapter on executions. And in there it says the penalty for not complying with the judge's order to garnish. And what the penalty is that you become liable for the judgment. And so I just went back a year or two and I went after all these companies. One of them was even Walmart. They just like lost the paperwork or something. And anyway, one of them was Verizon Wireless. And you just go after all these people with something called a motion for order to show cause against garnishee defendant. And in that motion, you basically show the court they were given this writ of garnishment, the sheriff served them, and they ignored it. They didn't take the money out of the check. So I want that employer to pay for the judgment that I won. According to Nevada law, that's the penalty. If you win a case for $1,000 and you garnish and they ignore your garnishment, they have to pay the $1,000 now. It's pretty serious. And I did it a bunch of times. I ended up getting a huge bonus in December because like all these companies were paying all this money from my motions just because they didn't comply with the writ of garnishment. By the way, the 2 tills that I tapped, the Jack in the Box till and the Verizon Wireless till, that's how that happened. Because both Verizon Wireless and Jack in the Box were given writ of garnishment and they ignored it. And so we went to the court, and the court they didn't show up. Neither Jack in the Box nor Verizon Wireless they didn't show up. The judge entered the judgment against the company, Verizon Wireless on one hand and Jack in the Box on the other. And then I just went and took the money out of their cash registers because they didn't want to pay. They just weren't paying attention. There's like a giant corporation and they just were like, meh. So they didn't show up to court. They didn't defend themselves. They didn't really have to pay until we took it out of their cash registers. And actually did get a call from both of them after that happened. I guess that actually got their attention. Because for Verizon Wireless and Jack in the Box, they were both till-tapped during like a busy day. So like there's all these, imagine you're in Verizon Wireless buying a phone and like 2 deputies run in and taking all this money out of there. Imagine how that looked. That didn't look good, but whatever. They just didn't want to comply with the order. Oh, one last thing before I end this video. Judgments in Nevada do expire unless you file an affidavit renewing the judgment. I don't know why I'm bringing this up. I mean, I guess we're on topic, so why not? This does happen, actually. It's happened a few times when I was in collections. It's like, I think it's like $60. After like the 5th year, you can file the affidavit to renew the judgment. I think they expire after 6 years, but you can't just file it whenever you want. You have to file it within like a certain amount of time before it expires. It's like a little window. You file your affidavit right then and there, you pay your $60, and then that extends the judgment for another 6 years. And there were actually people who they were like deadbeats. They had like no money, nothing for like 10 years. And then like they got their stuff together. They got their crap together, and then on year 13, they paid. So it's like, it actually does work to do that. Just letting you know, if you have a judgment against someone and it's like year 5, you might want to look into renewing that, because they may not have any job now, but you never know. Like 5 years later, 10 years later, they get their stuff together, and you do get interest for that whole time period. You get the legal rate of interest, and that can add up. So with that, I will go ahead and end this video. I'm not sure if people are going to have a lot of questions on this, but I do know that I've mentioned it offhandedly a couple of times in the past. Really long video, but maybe it'll actually help some people collect money on cases that they've won, because there is nothing like paying money and stress and going to court and winning and not getting paid. That is the worst. Because for me, I lost sleep. When I first went to court, I wasn't like confident. I was scared. And, to win and then get nothing is aggravating. So this is how you can do it. It takes a lot of work, but it's interesting to learn how the process works. And it's also interesting to know that a regular person can do it. A regular person, not a lawyer, no license to practice law, just regular old you, can go to court and get writs of execution, can take writs of garnishment to the sheriff and get them, satisfied. Just a regular old person. You have that power. You have the power to tap a till. You have a power to send the sheriffs to a place of business and empty out a cash register. That's a pretty cool thing that you can do. Of course, you deserve it because you won your lawsuit. So I'm not saying that you should just harass people with this. You got to go to court and win. And then when they refuse to pay you, that's when you start using all this stuff. Don't just, yeah. So if anyone has any questions, feel free to post them in the comments below, send an email. With that, I'll see you guys next time.